Welcome everyone to Current in 30, the 30-minute webinar series brought to you by the Current Consulting Group. We are thrilled to have you with us. To briefly introduce this series, each session is designed to keep you informed, efficient, and ahead of the curve. On the second and fourth Mondays of each month throughout 2026, we'll break down key things you need to know about workplace drug screening, from emerging trends and regulatory updates to best practices and practical implementation tips. If you missed our previous sessions, please visit our website, currentconsultinggroup.com, or our YouTube channel at Current Consulting Group to view those sessions. Thank you for joining us today. I'm Greta Walsh of the Current Consulting Group, and today's presentation is titled, What Every Employer Should Know About Marijuana Rescheduling. This presentation qualifies for half of a professional development credit from SHRM and HRCI for those who attend today's presentation in its entirety. Today's presentation welcomes the founder and president of the Current Consulting Group, Bill Current. Among Bill's many accomplishments, he founded the Current Consulting Group in 1998. He is the former VP of Consulting at Employee Information Services. He is a former executive director of the American Council for Drug Education. He is the former director of the Institute for a Drug-Free Workplace. He has authored 11 books on substance abuse prevention and drug testing, including his 2026 release, What Every Employer Should Know About Marijuana. And lastly, Bill is currently a member of the Board of Directors at Endesa and Board of Trustees at the Endesa Foundation. And now it's my pleasure to turn it over to our presenter, Bill Current from the Current Consulting Group.
Well, thank you very much, Greta, and welcome everyone to today's presentation. We're going to be talking about a subject that has just created a lot of confusion and chaos, the rescheduling of marijuana. And I recently wrote a book, as Greta mentioned, What Every Employer Should Know About Marijuana. And we went to print just before a lot of the most recent developments with rescheduling took place. So I wrote an article that was basically like a chapter of the book if I had all of this information before we went to print. And so that's what I'm going to present to you today, like a question and answer guide to rescheduling in the same format that you find in the book. So we'll follow this basic format. What is rescheduling? How does it happen? What rescheduling does and does not mean, rescheduling and the DOT regulations, and how will rescheduling affect the future of drug testing. And if you'd like to read our book, What Every Employer Should Know About Marijuana, you can find it on Amazon. Right now, it's available as a digital book only. So it's an ebook that you can read through the Kindle app available through Amazon. It's a free downloaded app. And then I'd give the book away if I could, because I'd like everybody to read it, but Amazon won't allow that. So we priced it at a very modest $10. Amazon gets a chunk of that. But for $10, you get 191 pages of great information with a lot of stats and studies and reports, fully cited so that you can go back and find the original source of all the information that we put in there. So I highly recommend it. I think you'll find it very valuable. And combined with today's presentation on what every employer should know about rescheduling, I think you'll have a pretty comprehensive view of the marijuana situation today. Now, I'm going to make some references throughout today's presentation to Current Consulting Group's 28th Annual Drug Testing Industry Survey. And I just want to acknowledge the companies that helped sponsor the survey this year: Abbott, ClearStar, Synergy, DESA, DrugPack, HASC, Endesa, Premier Biotech, and Quest Diagnostics. Thank you again to these corporations and organizations for helping to make this year's survey possible. As I mentioned, it's the 28th annual. We've been doing this since the first year I organized the company in 1998. So if you have questions about the survey beyond the statistics I'm going to share today, let us know. We'd be happy to share it with you. And you can find a lot of the information available for free at our website at currentconsultinggroup.com. But I'm going to start with some stats from this year's, from this year's survey. Now, some of the stats I'll share are from last year's employer survey. We do 2 surveys every year, one of the industry and one of employers. This is from the industry survey. So we asked the question of people in the drug testing business, why do you believe employers stop conducting drug testing altogether. And you can see right in the middle, that long orange horizontal bar, 64%, that was the number one response, reasons related to the legalization of marijuana. Now, that doesn't mean that 64% of their clients have dropped drug testing, but just they believe that that is the number one reason why a company will stop drug testing if they choose to discontinue their program. Second was that the marijuana legalization issue makes it harder to hire new people. And you see that's 55%. That's typically companies that don't do away with drug testing, but maybe do away with pre-employment testing or pre-employment testing for marijuana only. So you run into some state law issues, of course, but marijuana is complicating things for a lot of companies right now. And so, and that's what we're going to get into with the rescheduling. Another result, and this was from our employer survey, what are the biggest challenges to performing drug tests? And you can see down there about 2/3 of the way down, the legalization of marijuana, 34%, one of the top responses as a reason for drug testing being more complicated than it needs to be. Now, I highlighted the response before and after that 34%. 25% said state drug testing laws, and 20% said keeping our policy up to date. Those are all things that we do here at the Current Consulting Group. So there's a shameless plug for us. But a lot of those state drug testing law issues today are related to legal marijuana laws in over 40 states. And keeping your policy up to date has a lot to do with those laws as well. A lot of companies, when we write a policy for them, will ask us, you know, we're in 25 states, we're in 18 states, we're in 10 states, whatever it is. And they'll ask us, you know, which state law do we have to comply with? Do we base our policy on our home state or one of these other states? And the answer is all of them. You must have individual addendums to your base policy for all the different state laws that apply to you. So for example, if you're in California and Texas, but you're headquartered in Texas, you're going to use Texas sort of as the starting point for your policy, but you're not going to want to base your entire company policy on the very restrictive nature of drug testing laws in California. So you're going to want an addendum for California, especially as it relates to marijuana. As you know, in California, there are restrictions on what you can do with a drug test result from a test that only can reveal the presence of the metabolite of cannabis, which is urine testing. But it doesn't restrict a test that will show the parent drug, which is oral fluid testing. So those things get factored in when you do a policy, but it's part of how the marijuana issue is complicating things nowadays for employers. So let's talk about what rescheduling is and how it happens. And this is just a primer, okay? You can go deep into this if you want to look it up online. But basically speaking, the effort to reschedule marijuana really sort of has been around for a long time. But it picked up steam during the Biden administration, and then President Trump, back in December, signed an executive order directing his administration to expedite the process of rescheduling marijuana, to expand research on medical uses of marijuana and CBD, and to create business benefits to those in the marijuana business, in the cannabis industry. Now, it wasn't until April of this year, but back in April, the interim Attorney General, Todd Blanche, signed a directive to begin that process of officially moving marijuana to Schedule 3. Among other things, look at that last bullet. Among other things, rescheduling will make marijuana obtainable for medical reasons with a prescription. I'm going to get into that here in a minute because that's very confusing. It's not as simple as that. Okay. Now, rescheduling is part of the Controlled Substances Act. We hear about that all the time. And that's assigned to the authority for rescheduling to the U.S. Attorney General, who over the years delegates that to the Drug Enforcement Administration, the DEA. And then the Department of Health and Human Services, through the Food and Drug Administration, provides information to the DEA, scientific and medical evaluations, to determine, for the DEA to determine, how a drug will get scheduled, if it'll be scheduled, and where it'll be scheduled. There are 5 different levels of scheduling. It's important to note also that Congress can schedule or reschedule or remove substances from control through legislation, though. So most of what we're talking about here with marijuana has been done administratively, but Congress can do something legislatively. So the process begins with the DEA. And at the request of HHS, as you see there in that first bullet under initiation or petition, or through an interested party like a drug manufacturer, a medical organization, another government agency, that process can begin through any of these entities, okay? And the DEA will request then for Health and Human Services to conduct a scientific and medical evaluation and then make a recommendation to the DEA as to if the drug should be scheduled, and if so, what level. There's 8 different factors that go into the FDA's evaluation of a drug. And it's interesting because when the FDA makes that recommendation, it's binding on the DEA in terms of the science or the medical matters related to that substance. So, for example, as you see in there in the last sentence, if HHS recommends that a substance not be controlled, the DEA may not place it under control. In other words, that HHS/FDA recommendation is binding, and the DEA has to follow it. Okay, so it's not the DEA that's actually doing the medical evaluation or the scientific evaluation. It's the FDA under the auspices of HHS. Now, third step, the DEA will then review and make a determination based on those findings from FDA, HHS. And then the number 4 there, if the DEA proceeds, it generally publishes a proposed rule, accepts public comments. So there's a notice of proposed rulemaking and a comment period in which the public and anybody else who wants to weigh in on it may do so. And they conduct an administrative hearing, which recently part of that took place with the rescheduling of marijuana, and NDASA was very instrumental in participating in that. But usually that's the process, okay? Now, there is a difference between the 5 levels of scheduled drugs. There's Schedule 1, 2, 3, 4, and 5. A Schedule 1 drug is the most severe, dangerous type of drug. That's where you find heroin, LSD, methaqualone, ecstasy, and previously marijuana. Okay, these are drugs that have no currently accepted medical use in the United States. They lack any accepted safety for use under medical supervision, and there's a high potential for abuse. Think about that. That's key here, right? Under the Schedule 3 drugs, and Schedule 2 drugs are very similar to Schedule 1, but Schedule 3 substances or chemicals, quote, have a potential for abuse less than substances in Schedule 1 and 2, and abuse may lead to moderate or low physical dependence on high psychological dependence. I point that out because in my book, What Every Employer Should Know About Marijuana, I cite multiple studies that show the immediate and long-term effects of marijuana on the body, on the heart, on the brain, especially when people start using marijuana at a very early age. I cite all of those in there because the potential for abuse is definitely there. We're seeing a dramatic increase in the number of people who admit that they use marijuana every day. And the average use, first-time use, is 14 years. Average, meaning there are plenty that are below or younger than 14. Now look at the last bullet. Schedule 3 drugs include products containing less than 90 milligrams of codeine per dosage, like Tylenol with codeine. So essentially what the Trump administration is telling us is that marijuana is equal to Tylenol with codeine, as opposed to equal with heroin, LSD, methaqualone, and ecstasy. To me, it doesn't make sense, but, and I apologize, I'm inserting a little bit of personal bias there, but that's what they're telling us by rescheduling marijuana from Schedule 1 to Schedule 3. Now, let's talk about what rescheduling does and does not mean, okay? Because this is where there's a lot of confusion. Does the rescheduling of marijuana mean marijuana is now legal federally? We know a lot of states have legalized it for either medicinal use or recreational use, but has the federal government now legalized marijuana? Well, the answer to that is no. The rescheduling of marijuana is not the same as the legalization of marijuana at the federal level. Okay. Look at that second bullet. This is key. The Trump administration's directive to reschedule marijuana only applies to so-called medical marijuana. Recreational marijuana, which a lot of states have recreational marijuana laws, marijuana for recreational use is still considered a Schedule I drug. In other words, it's still illegal under federal law. What the Trump administration is saying is that for medical purposes, it's now rescheduled as Schedule III. Okay. So I'm going to get into that in a minute, but it's important to understand the difference between medical marijuana and recreational marijuana. Recreational marijuana use, despite being legalized in many states, remains illegal under federal law. Has marijuana officially been reclassified as a Schedule III drug? Well, yes and no. And I say yes and no because you can go onto the website, the DEA website, and you'll find that it is still listed as a Schedule I drug as marijuana, cannabis, and marijuana extract, but second bullet, naturally derived delta-9 tetrahydrocannabinol is in a U.S. Food and Drug Administration (FDA) approved product, or in marijuana subject to a state medical marijuana license is listed as Schedule III. There's a difference, right? Is there a U.S. FDA approved marijuana product? I mean, natural marijuana, not chemical marijuana like Marinol? The answer to that is no. And in fact, I've got a slide coming up. Yeah, this is it. I'm not an expert on it, the science of it, but there was an excellent article written by Sue Rescheduling. She's been in the drug prevention business for a long, long time. She founded the National Families in Action. She wrote the Marijuana Report, very famous, very well respected. I suggest you go find this article that she wrote on the rescheduling, because she gets into the details in a way that I couldn't do justice. But she does talk about the difference between chemical marijuana products or chemically produced marijuana products and natural marijuana. So I highly recommend that. I recommend it to the Trump administration too. I think they'd benefit by reading it. Now, can employers still test applicants and employees for marijuana? The answer is yes. Rescheduling does not prohibit employers from testing for marijuana, as long as you do so in compliance with the state laws that apply to you. Like I talked about earlier, if you're in multiple states, you got to look at all the different state laws. There may be a state that has a legal marijuana law that prohibits discrimination against medical marijuana users. There may be some that require employers to have or to provide some evidence of impairment before taking adverse employment action based on a positive marijuana test, et cetera, et cetera. Comply with those laws, but you can still test for marijuana. So rescheduling does not affect that at this time. And it doesn't affect the federal regulations directly, okay? I'll get into that in detail. But before I do that, that's the whole next section. Before I do that, are state drug testing laws affected by rescheduling? And the answer is yeah, possibly, because many state drug testing laws simply punt on the issue of how drug testing gets conducted in their state, and they defer to the federal regulations, Part 40, maybe FMCSA, et cetera. But that can be governed at the state level, but based on federal regulations for things like specimen collections, which laboratories you can use, which drugs you can test for, the cutoff levels for the actual test, confirmation testing, et cetera. So the list of drugs you can test for may differ from state to state to state, depending on their law and depending on how they react to rescheduling. So the advice here is to be alert, look at that. You may need to adjust your drug testing policy. If you need help with that, let us know. But you have to comply with all the states where you have business operations. Now, let's talk about rescheduling and DOT. Can the U.S. Department of Transportation still require covered employers to test for marijuana? The answer is yes. That has not changed. DOT has been very clear about that. I'm not saying it won't change, maybe, but right now, DOT still requires covered employers to test for marijuana. applicants and employees both. And look at that last bullet, the last line, follow all mandated actions when someone tests positive. So you're testing a truck driver, test positive for marijuana. He's violated the regulations. You must remove him or her from driving a truck with this, under the individual CDL, et cetera, et cetera. Nothing right now. And this, the day I'm recording this, it could change tomorrow, but right now, nothing changes per the DOT drug and alcohol testing regulations. And DOT has put out statements on this, okay? Now, I asked the question, going forward, does rescheduling endanger DOT's authority to mandate marijuana testing? I'm on the board of directors of the National Drug and Alcohol Screening Association, NDASA, and we're very concerned about that. We have been very vocal and advocating strenuously on this issue. We believe that there is a possibility that if rescheduling goes through as currently written, it could interfere with DOT's authority to require testing for marijuana, which would be catastrophic for public transportation safety. So we've been advocating for a safety carve-out. And I have to give a lot of credit to Joe McGuire, the executive director, and many of the members of the board and other members of NDASA who have been out there lobbying, campaigning, going to DC, et cetera. We want to ensure that DOT retains the authority to require covered employers to test for marijuana. A safety carve out, we believe, can make that happen. Okay. So, as part of our industry survey this year, we asked the question, will rescheduling, this is a question we posed to drug testing professionals, will rescheduling marijuana result in DOT no longer having authority to require covered employers to test for marijuana? Absent a safety carve out, 46% said it's hard to say. And that's true. We don't know. But 42% said no, and 12% think it will. So it's an issue that's still up in the air in a lot of ways. Now, how does rescheduling affect what MROs can do with drug test results that are positive for marijuana? Can they reverse a positive and turn it into a negative or report it as a negative if the person was using it for medical purposes? No. DOT issued a statement on May 26th of this year clarifying this issue. Marijuana rescheduling does not change DOT drug testing requirements. MROs cannot verify a laboratory confirmed marijuana positive as negative. Okay, very, very important. This could all change, of course. There's a lot of stuff left up in the air, but as of right now, under DOT's regulations, rescheduling does not give MROs the authority to change a positive to a negative based on a person's excuse of using marijuana for medical reasons. Now, can or should an MRO report a DOT positive as a negative if the person was using it for medical purposes? Part 2, state dispensed marijuana is not an FDA approved prescription drug. This is what I was referring to earlier, and you can find a lot of good explanation of this in Sue Resche's article that I referred to earlier. A legitimate medical explanation requires the lawful use of an FDA-approved prescribed controlled substance. Marijuana use right now remains incompatible with DOT's safety-sensitive functions. Very important. Now, why is this important to employers? Because DOT-regulated employers should understand this is very important, and this is where there's been a lot of confusion. Marijuana rescheduling does not change any of their obligations or responsibilities under the DOT drug testing rules. You must still comply with the rules, and as of right now, those rules still require employers to test for marijuana. In addition, marijuana use is not compatible with safety-sensitive functions. I stress that again. Now, how will rescheduling affect the future of drug testing beyond the DOT regulations, et cetera? I turn again to our drug testing industry survey. We asked that question. 36% said some, but not many of their employers will stop testing for marijuana. 28% said many employers will stop testing for marijuana. Those were the two biggest responses individually. But 17% said they don't know, but their clients are asking. And 19% said it will have little effect to no effect on drug testing. Very interesting. And then Why establish and maintain a drug testing program? Safety. Number one response, 78% to promote safety. What benefits do you get from drug testing? Safety. Improve safety in the workplace. I think that many employers will look at the whole marijuana issue and they'll consider why they do drug testing in the first place, what benefits they get from drug testing, and determine that they're still going to test. And where they can test for marijuana, they're going to test for marijuana because it's a safety issue, which is a bottom line issue for many companies. So, anything else? Well, make sure your policy is up to date. You really cannot take the chance of hiring and employing marijuana users and then having them cause an accident, file a workers' comp claim, cause your company to get sued by somebody that they've hurt, or property damage that they've caused. I think number 2 bullet, if anything, the rescheduling of marijuana coupled with the predictable increase in marijuana use will probably embolden most employers to take a firm stand, maybe even a stronger stand. Regardless of what these laws say, you as an employer can, and I would argue should, prohibit employees from bringing marijuana to the workplace. Prohibit employees from using marijuana while on the job, and prohibit employees from being at work while under the influence or impaired by marijuana. There's no state that requires you to accommodate individuals bringing marijuana to work or using marijuana while on the job or being impaired by marijuana while at work. Now, a drug test doesn't prove impairment. I know that. I understand that. But it helps to identify somebody who has violated your company policy by being at work under the influence or maybe even using marijuana while on the job. So, how can the Current Consulting Group help you? Well, we do a lot of different things. We write drug testing policies, we provide supervisor training, which will be more and more critical in the future, given the legalization of marijuana. And we keep our clients up to date with legislative updates every month on the progress of legislation at the state level and new laws that get passed. So let us know if we can help you in any of those areas. And also, just remember our new book, What Every Employer Should Know About Marijuana. I think you'll like it. I think it will provide great information and answer a lot of questions for you. And if you're on the fence about whether or not you should test for marijuana, this might help you in making a sound, educated decision. So with that, I want to thank everybody for joining us today. If you have any future webinar needs, we're here, as Greta said, twice a month with Current and 30. And we'd be happy to help you with any of that. August 24th, we'll feature a webinar with Yvette Baker, one of the attorneys who works for us, and if you'd like to look at past episodes of Current and 30 or of our podcast Currently Speaking, you can find them at our website at currentconsultinggroup.com. So with that, I will turn it back over to Greta. Thank you.
Thank you, Bill, and thank you to everyone else joining us for today's edition of Current and 30. We hope that today's insights have helped you stay informed and confident in your workplace drug screening decisions. As a reminder, this presentation was recorded and you will receive instructions in a few days informing you how to access the recording. Additionally, this presentation qualified for half of a professional development credit from Sherman HRCI for those who attended today's presentation in its entirety. If you have met that requirement, you will be emailed those activity IDs. Remember, we'll be back every second and fourth Monday of 2026 with things you need to know to stay current in this industry. Be sure to follow the Current Consulting Group and check your inbox for upcoming session details. Until next time, stay current and have a great day.